It lets him know the...
Welcome back to Law News Network, everybody. This is Jesse Weber. Thanks for joining us. We're cutting out of the prior testimony in the Toledo case because we have a very special guest with us. We have criminal defense attorney Deborah Blum. Deborah, great to see you as always. We want to talk about Toledo, so thank you for joining us.
Thank you for having me.
Of course. So there's a lot to talk about from yesterday, today. I want to first start with today, and then we'll get into everything about this case. First question I have for you, the big thing here is about letting that video in, okay? The judge ruled that they can let statements that Toledo made in that interrogation with police in, and namely, what they were discussing with the attorneys was the statements that he made to police that he admitted to karate chopping his wife in the throat. That can be allowed in. How is that possible?
Well, it's a statement. I'm sure he was Mirandized. So technically the statement comes in. Of course, there are arguments you get to make as the defense attorney, such as if you did not have timely notice of it, but that doesn't seem to be the case here because that's a hard and fast rule that the video wouldn't come in. But so long as your client was read his or her Miranda rights and the judge doesn't find any other violations, such as the police officers using undue force in getting a confession, it's going to come in.
But how is it? I don't know if his attorneys were present. And if they were not present, or if they were present, I still don't understand how this man could make this such incriminating statement. Again, the idea is he might be admitting to killing his wife, but he says he has absolutely nothing to do with his children. We'll talk about that in a minute. But if his attorneys were there, how is it possible he said this? And if they weren't there, aren't they in arms saying that we weren't present, he shouldn't have made this statement?
Well, it's before the right to counsel attaches. The right to counsel only attaches if your client requests an attorney to be present. I find that in 9 out of 10 times, your client giving a statement is very damaging to them. But in 1 out of 10 cases, I have a case right now where my client gave a statement and the prosecutor actually found him to be truthful, because I also believe he's being truthful, and now most likely will drop the charges against my client because of my client's own statement. But in this case, the defendant said very damaging things that are going to be used against him. Of course, his defense attorney is going to argue that he made a confession because he had been in police custody for XYZ amount of time and that he was just willing to say anything. A lot of times I've found that my clients will tell me that the police or the district attorney steps in and they videotape only a portion of it, and then the police will make them a promise, oh, if you admit to doing this, then we're going to drop the charges or significantly reduce the charges. And of course that's never on the videotape, and you also make that during the pretrial hearing to suppress the videotape, but oftentimes the judge does not rule in your client's favor.
Okay. The jury hasn't heard this yet, okay? They've been sent home for the day. We're expecting them to hear this tomorrow. Those are great arguments. Is any of this going to fly for the jury, or is it already, once they hear that, that's it? He is now definitely going to be convicted of second-degree murder.
Well, I can only speak to what happens in New York State. In New York State, this issue is usually determined prior to going into trial because you'll have a hearing on the admissibility of the statement. Once the judge rules that a statement can come in, prior to trial, the defense attorney, like they did here, will make an application for certain portions of the admission to be redacted. So here they asked for him saying that he wanted to commit suicide. I believe that's the issue, to take that out and not allow the jury to hear it. Similar to a 911 call, defense counsel or the prosecutor could ask for certain parts of it not to come in, and then it's going to be up to the judge. You're going to want to argue cases that come out of that courthouse or the appellate division of where the case is taking place as precedents and say, look, the rule of this court is that you should not let this in because it's too prejudicial for my client, and in this case it was a very similar circumstance and the judge didn't allow it in there either.
Well, some of the prejudicial things that we've seen so far, the discussion that we've seen so far, is about statements about where the bodies might be. And this is a recap for our viewers who might not have seen this. The judge is having a back and forth with attorneys about that the bodies might have been left in a gator pit. And there's a question about whether Tyshawn Jackson, who's one of the witnesses in this case, he was actually involved in dumping those bodies. The question of prejudicial or not comes into play because they seem to be saying, well, maybe what is the idea of prejudicial for a gator pit? You know, there's gators everywhere, but maybe it's the idea that the bodies would be how you got rid of the bodies in such a manner. The judge ultimately ruled that it's not prejudicial and can come in. My question to you, to go back to the idea of him karate chopping her in the throat, the jurors hear that, the defense is not able to get it out, maybe they're not able to explain it away. In the minds of the jurors, if they know, or they're in their minds, if this guy is guilty of second-degree murder, isn't that an automatic attachment to the first-degree murder of those 2 children?
I have to, unfortunately, for these defense attorneys, say yes. This is a tragic situation.
Because how do you separate them, right?
I don't think that the jury is going to be able to, and I don't know that based on what I know from this case that I would expect them to. You have DNA evidence linking him to the daughter and her disappearance, or at least in my opinion, that's a very easy thing for the prosecutor to argue, is that his DNA was found on this young girl's items or vice versa. We know that he did this. He put things in a trash can. He wanted to hide the evidence. No, we don't have the body, but you know, in that situation, I don't necessarily agree with the judge's ruling. I've had cases where a gun has come in for demonstrative purposes to show the jury, oh, this was the type of gun that was used during the commission of the crime, but it wasn't the actual gun. And I think things like that confuse the jurors because they're going to link the 2.
You mean demonstrative, you're using it to make a point. It's not actual evidence. It's not like a boot. It's not like a piece of clothing, but it's used to make a point. Am I correct? Okay. So let's talk. I do want to show our viewers before, because Deborah, I have so many questions about this case, and I'm glad you're here. But I do want to show our viewers what you were talking about that suicide tape, about that suicide video, a little bit about what we're talking about here, because it seems to be that when Mr. Toledo was in custody, this is what the part of the tape is going to show, he tried to commit suicide. He was actually rushed to the hospital at one point. And I'll read you actually about when this happened. This happened in 2013. Mr. Toledo, he was being questioned about the disappearance, because this wasn't a murder case yet, okay? This was just a disappearance about the wife and the 2 kids. He attempted suicide in a Volusia County Sheriff's Office bathroom, but he wasn't successful, and they rushed him to Halifax Health Medical Center into Daytona Beach with non-life-threatening injuries at about 11:30 a.m. But the point is, why does the defense not want this in? Well, let's take a look at the video, and then Deborah and I will talk a little bit more about it.
I need you. Go. Break it. I got it. On the way.
That didn't sound very good. That is the alleged Louis Toledo suicide attempt in that case. What you were watching is he had an interrogation video with police, and when he excused himself to go to the bathroom, he tried to commit suicide. Now the question becomes, can jurors know about this? Can this be admitted for their viewing? And again, jury is out right now. Court is out of session today. It's coming back tomorrow, but will they be able to hear that? Who should I ask but Deborah Blum, our criminal defense attorney, here to talk about it. Deborah, what's the danger of the jury seeing this man trying to commit a suicide attempt?
Well, I think it just does not put him in a good light. I'm not sure why the judge ruled to allow this in. It, to me, is not part and parcel of his confession to the crime. It just adds to the jury thinking that he's guilty, and that is not supposed to be allowed in.
But we know that this happened before he was actually charged with anything. We know that this happened before they even knew that the Giusseni and the two kids were murdered, or alleged murder charges were brought. So the question becomes, it was a missing persons case. Does that show that if it was a missing persons case and he tried to commit suicide, it's a consciousness of guilt kind of situation?
Yeah, I think it's exactly that, and that's why the jury shouldn't know about this, because it's a balancing test. And here there are so many things pointing to this defendant being the one that committed this crime, and this is an uncharged act, or, so there has to be a hearing or at least oral argument to determine its admission, and obviously the judge decided it should come in. And the reason that we always stick to as defense attorneys is it's too highly prejudicial. And yes, I think people are going to think that because when learning about her disappearance from the police, he understood that he was a suspect in that, and him trying to commit suicide certainly does not put him in the most favorable light. I actually have a funny story about being at a police precinct with a client. We went to do a voluntary surrender, and this is a very lovely young man, and he was very nervous about a prior matter possibly coming up. So we go to the police precinct, and it's not like going to summer camp. We get there, and within 5 minutes he's asking for water, he's asking to go to the bathroom. So when a defendant goes to the bathroom, they have to be escorted from their cell to the bathroom, which is oftentimes on a different floor. So you have like 3 to 5 police officers walking behind your client. The whole thing is a major production. So for this defendant that's accused of murdering his wife and her 2 children to actually get to the bathroom, you don't know the production that went into it before he arrived at the bathroom.
Is there any way you could have like a cause of action against the police for allowing this to happen? His guy's life was in jeopardy because they didn't properly watch him. Do you see anything like that happen?
I mean, I wouldn't find it so strange if an attorney decided to go after them for that, but they might have a statute of limitations issue. Should at least line this defendant's pockets a bit. I'm totally joking. But yes, they might have a cause of action. I actually was able to get my client a violation on a drinking and driving matter because during his examination at the police precinct where he was doing the standardized field sobriety test, he kept saying that I have to go to the bathroom, and I believe that interfered with his ability to perform the test. So what would have otherwise been a plea to the charge became a violation because of this videotape of my client asking to go to the bathroom.
Videotapes are not doing so well today. Not doing so well today. Let's talk about the nitty-gritty of this case a little bit, though. Yesterday, we saw there was a discussion between the defense and the prosecution, and it said, okay, the prosecution's shown that there's a missing person, that there's 3 missing people, Yesenia Suarez, Talia, and Michael. But you haven't quite proven that there's a murder. And the prosecution said, that's not true. We've blatantly shown that there's a murder, and they've clearly shown that there's a murder, and that's where we are at right now. Where do you think that this case really went from siding with the prosecution and showing that this really is a murder? That, look, we don't have the bodies, and we'll get into that in a little bit. But why do we know that this is a murder? And is it because of that DNA evidence that we saw yesterday? How do we know now that this is a murder case?
I think that yesterday was a crucial time period for the prosecution when all of this testimony by their investigator about the DNA evidence linking Toledo to this crime, I think that was a game changer.
Let's talk about that, because what we saw was a testimony from a DNA analyst who said the DNA of 9-year-old Talia Otto was found in the blood on a closet door, the master bathroom, on the trunk mat of her mother's car, and on a black boot that investigators say belongs to Luis Toledo. Is this a closed case?
I think so, yes. I actually was with a client the other day when we agreed to submit to a DNA swab, so the audience at home understands what that is. It's not one of the most invasive procedures. You just simply swab somebody inside of their cheek 10 times on each side. So I'm not sure if this defendant agreed to give his DNA or if there was a court order to receive his DNA. That's an application that the prosecution has to make unless your client outright agrees to do so. So I'm not sure how they received his DNA here, or maybe they possibly had it on file from before, because I believed he's believed to be a Latin King member. So this is not the greatest guy to begin with. And then all of these, which I don't believe the jury is hearing about in this case, but this DNA evidence is extremely damaging, especially the fact that they found the young girl's blood on his boot.
Okay, but if I was the defense attorney, again, this doesn't seem good for him at all. This seems like a closed case, but isn't the other argument is, okay, we know that she was attacked. We know that there was blood in the closet, in the bathroom, her mother's car. Okay, how does that link it to Toledo? Well, the boot, isn't it possible? They checked the inside of that boot for DNA, and there was just too many mixtures of DNA to determine conclusively complete DNA profile, so they couldn't tell who was actually wearing those boots and at what point. Because it was actually interesting, one of the things they said is when you wear socks, you pick up all this DNA, so it's hard to tell from the inside of a boot. Couldn't anybody have worn Mr. Toledo's boots in an attempt to frame him in this way? And how do we know it's actually Toledo's boots?
Well, I hope that the defense attorneys in this case are listening to your commentary, because you're giving them excellent things to say during their closings. And actually, I'd like you to help with the defense of some of my clients, because you're doing an excellent job in coming up with alternative theories. I think that one of the really bad things here is that investigators also found 2 boots they say belong to Toledo inside of this dumpster.
I want to talk about that dumpster. I'm so glad you brought it up, because prosecutors showed jurors pictures of items that were fished out of a dumpster near a Petco store near the Seminole Town Center Mall in Sanford. At the bottom of the trash receptacle, investigators found stuffed animals. They found a vacuum cleaner, and they found a black cape like the one that people wear when they get a haircut. And remember, Toledo was in barber school, and even the vacuum cleaner smelled very strong of cleaning supplies, as if someone tried to clean it up. Why is all this stuff at the bottom of the dumpster? And doesn't this, again, tie directly to Toledo?
I mean, it definitely ties directly to him. And also the prosecution is trying to make a link between the police officer or investigator who first went to his home and testified before this jury that his home smelled like cleaning agent. So they're going to make a direct link to the vacuum cleaner. And it's very sad that the stuffed animals were found in the dumpster. Yeah. And again, we can play defense attorney here and say that anybody could have had one of those black black capes. Just because he was becoming a barber does not mean that he personally possessed it. Maybe it's something he got at school. It doesn't mean he had one at home. It doesn't mean that this was his. I don't know that there's any direct DNA evidence linking him to the barber cape. So there are plenty of arguments that the defense is going to make here. It's just I think that this is a case where it seems like the prosecution, beyond a reasonable doubt, has enough things to pin him to being the perpetrator of this crime, including the fact that the man that Yesenia was having an affair with, Yesenia Suarez was having an affair with, testified about an argument he witnessed between this husband and wife.
Yeah, reasonable doubt. You really said it. Anything's possible. Of course, someone else could have done it, but it's up for the jurors to determine if all the evidence presented by the prosecution shows beyond a reasonable doubt that he is guilty of second-degree and first-degree murders. And I hope none of the jurors are watching right now, because they were sent home and were allowed to go to work, and they were told not to follow or research or look at anything about this case or talk to anybody about this case. So none of you better be watching. And the question that I have for you is, sending jurors home for the day and allowing them to go to work, that's a risk.
Well, they're not sequestered. So, you know, these people are doing their civic duty, and they should be applauded for doing so. I know that many people often try to get out of jury duty, and these people actually agreed to serve, and it's hard to take a step away from your daily life. These are people that have responsibilities. They're employed. Their employers are inconvenienced by them having to serve. So I understand the judge wanting to give them some sense of normalcy. So also there might be some arguments going on between counsel or preparation due to the judge's ruling. You know, sometimes if the judge makes an unexpected ruling, as the attorney, whether you're the prosecutor or the defense attorney, you have to then do additional work that you weren't planning on. So there are a million reasons why they could have been dismissed early today, and good for them.
But how do you track them? How do you make sure they really didn't talk to anybody? The good thing is, as much as there's a problem with social media, you can track that. If people are communicating, posting messages, we saw it in Jessica Chambers. One of the jurors posted something about jury duty. They were kicked off the jury. How do you know whether somebody is talking about this case or is influenced by somebody at work? I mean, this is a case that is capturing the nation's attention. I mean, we're following this case on LawNewz Network. Everybody's watching it. It's a pretty high-profile case.
Right. I mean, venue was actually changed. It's being tried in a different county because of the notoriety of this matter. So, you know, I think that jurors tend to do the right thing. I think that they try to follow the judge's instructions. I think the concern is more when they go to lunch and speak amongst themselves. They're going to discuss the case with the fellow jurors. But I know that jurors really try ultimately to do the right thing. And someone going online and posting on social media, that's just an absolute no-no, and kicking him off the jury was the right thing to do.
Deborah, we're going to talk a little bit more about this case, particularly what it's like to convict somebody when there's no bodies in this case. We'll get into that in a minute. I know we have you here for a little bit, but I do want to talk about what's happening today, because one of the things that's going back and forth with the judge and the attorneys is about what parts of that interrogation video can be let in and which parts cannot. And as we talked about, one of the key points is that suicide attempt from Mr. Toledo, that he did try to kill himself while he was in police custody. And can the jurors know about that? We talked about it at the beginning of this segment, but now we're going to give you a glimpse of how how the attorneys talk about this with the judge. We get a first-hand glimpse about how this argument's made. So I'd like to play for you right now.
As far as it relates to the suicide issue, Judge, the defense is correct. There has to be a nexus between the conduct of attempting to commit suicide and the attempt to avoid prosecution. And so let me just briefly lay a record to tell us where we are prior to the interview on the 26th. Prior to the interview on the 26th, the portion that we just watched, the defendant has had 3 conversations with law enforcement where he has gone from denying anything occurred at all and saying simply that his wife left him in the middle of the night and she can't be found. On the 23rd, that was his statement. On the 24th, he's been confronted with his guilt or evidence of his guilt, items that he's disposed of around the community. His statement immediately changes from, I don't know what you're talking about, she left, to, you're right, I killed my wife, Tyshawn Jackson killed the neighbors. And I'm paraphrasing for speed, but
Tyshawn Jackson killed the children.
Right, excuse me, I'm sorry, Tyshawn Jackson killed the children. And then Tyshawn Jackson was the one responsible for the disposal of all 3 bodies. I don't know where they are. It's essentially the defendant's position, and he holds that position on the 24th, the 25th, and then on the 26th. You read a portion of the transcript from the 26th where he calls investigators to the jail to talk with him in an effort to reveal information about where these bodies may have been hidden by Tyshawn Jackson, and that's the portion of the interview that precedes this attempt to commit suicide. As you recall, during this 45 or so minute interview, the defendant asks to use the bathroom on 3 separate occasions. He immediately comes in complaining of his stomach bothering him. He asks to use the bathroom, and during his second trip to the bathroom, which occurs somewhere around 25 minutes or so into the recording, he tells Sergeant Sheps to come with him. And what had happened on a previous trip is that 2 investigators escorted him to the bathroom. On the second trip, as he's leaving the room, he can be heard saying to Sergeant Sheps, "Just you." And Sergeant Sheps goes with him. What Sergeant Sheps will testify to when he comes to trial is, and he's already said in his deposition, and it's been reported several times by several officers, is that essentially when he gets to the bathroom with the defendant, the door remains open so that the defendant may be monitored. The defendant is using the restroom facilities, and there is a conversation that occurs between Sheps and the defendant, wherein the defendant tells Sheps, are you recording this? Sheps says yes. The defendant says, "Toss it," meaning toss your recorder. And so Sheps tosses his recorder and turns it off. The recorder breaks, and so that the interaction can't be recorded in any way. The conversation that follows is essentially that the defendant is asked more questions about where the bodies are, and during this moment that he's talking with investigator Sergeant Sheps, he tells Sergeant Sheps, "I'll never tell you where the bodies are," which is materially different than what he's maintained to this point in the case, where he blames Tyshawn Jackson for the murder of the children and the disposal of all 3 bodies. And so he changes his statement on the 26th for purposes known only to him, but it's a material change in statement. When they get back to the interview room, Sergeant Sheps then tries to lay as much of a record into the recording about the conversation that occurred in the bathroom, at which point the defendant then asks to use the restroom again. This is the 3rd trip to the restroom. He's excused from the room and taken from the interview room. You've seen the video. As he's taken around the corner, the audio in the video room is able to record several of the events. And just to kind of lay the record, he's excused from the interview room, and within seconds you hear the bathroom door close and you hear glass breaking, which is, I believe, the defendant breaking the mirror in the bathroom at the sheriff's office. You then hear someone banging or kicking on the door, which is one of or more than one of the 3 investigators that are involved on this particular occasion. Investigator Pagliari, Sergeant Sheps, and Investigator Brian Ford are attempting to kick the door open to get access back to the defendant. You then hear a long silence with running up and down the hallway, and then in a few minutes you hear a louder banging, which is where the investigators have gotten a battering ram and a taser, and they're breaking the door down in the Volusia County Sheriff's Office in an effort to gain access to the bathroom where defendant has concealed himself. They're eventually able to put a hole in the bathroom door, and just enough to get the taser in, and are able to taser the defendant, at which point he is dragged out of the bathroom onto the floor in the hallway, and you can begin to start hearing comments that occur between the investigator and the defendant. And I made some notes as we went, that there is some iteration of "tell me where they are" and "let me die." That the investigators are yelling at the defendant, "Tell me where they are, tell me where they are, tell me where they are now." And the defendant is responding, "Let me die, let me die, let me die." And that's just what you can hear in the recording. The investigators may have additional details that they have shared previously or will share at trial. But this occurred on at least 4 times during the recording that I was able to hear as it played here in open court. And so what the state has to show is that there's a relevant connection between the event itself and consciousness of guilt. And I would direct you to the Sloan case. It's 104 Southern 3rd, 1271. And I'd turn your attention to the middle of that case, but particularly if you look at the last 2 paragraphs, which are on 1274, what the court talks about here after citing the Penalver case and talking about the change in the law and the necessity to put forth this predicate. They then go on to say that where the defendant in Sloan actually attempted to commit suicide and then tried to flee from the state, because he was aware of the initiation of an investigation prior to those attempts. What happened is it was a sex case, and the mother of the victim told the defendant that the cops were looking at him. And so he then attempts to commit suicide, flees from the state. The court said that those 2 actions, both the attempt to commit suicide and the flight from the state, are relevant to show that he was attempting to avoid prosecution and was attempting to avoid being held accountable for his crimes. And I think that that's akin to the situation that we have here, where the defendant has already confessed to at least 1 murder, and then his statement materially changes on the 26th as it relates potentially to the other 2 murders, and certainly to the location of the bodies, which is apparently within his realm of knowledge. And so here I think we have sufficient facts to show a nexus between his consciousness of guilt and his attempt to commit suicide. And the state would ask you to allow presentation not only of the evidence of the suicide attempt, but also the recording, because I think it clearly demonstrates the order by which...
Welcome back to Law News Network, everybody. This is Jesse Weber. Thanks for joining us. You were watching a hearing in the Toledo case out of Florida. This is about whether or not... Remember, Toledo was in police interrogation video. He was under investigation. He was being interrogated by the police. And at one point, he tried to commit suicide. And now the question becomes, can the jury know about that? Can that part of the video, which we showed you earlier of him, you can hear the sounds of him trying to kill himself in the bathroom, can that be admitted for the jury? And there was a hearing with the judge to determine whether or not it could be allowed. And we were trying to figure out, does that determine consciousness of guilt, meaning whether or not he thought he was, whether or not that shows that he was guilty of something? Because at the time, there was no murder charges. It was just the disappearance of Yesenia Suarez and her 2 children. Well, to talk a little bit more about that, as well as some other questions in this case, I'm here with Deborah Blum, our criminal defense attorney for the day. Deborah, let's just recap a little bit about that suicide video. You heard the arguments that were being put forth by the prosecution, valid arguments about consciousness of guilt. What do you think?
I just think that this whole thing should be kept out. I don't agree with the judge's ruling. I mean, number one, I'd like to point out why the police had a mirror in their bathroom. I don't know. In most of the courthouses I go to, especially in state criminal court, also police precincts, a lot of times they don't have mirrors for this very reason, because people are going to smash it in and potentially use it as a weapon. Or
you got to see how you look. You got to see how you look.
I mean, I find it very upsetting when I go into the bathroom in family court or criminal court and there's no mirror, because I like to look to see that I look presentable for court. But I do understand the public policy reason why there isn't a mirror. So that's number one. I don't know why there was a mirror in this police precinct bathroom. Number two, this interrogation took place prior to him facing murder charges. This was just a disappearance at that time. That's one of the arguments I would have made as the defense attorney, that he wasn't even accused of murder. So now to bring this in when he's facing murder charges, and at that time it was something completely different, that's like trickery or deceit. I don't know. You have to try to make up these arguments, and I'm sure that this is something his defense attorneys had time to prepare. I do think that it goes with what we keep talking about, the highly prejudicial. They have other things linking him to these murders, and I don't think that this is something that should come before the juror, because it's not a criminal act. He's not being charged. It's not like there's some crime of suicide. So I just think it should stay out.
Deborah, we haven't had a chance to talk about this case in length, so now we are having the opportunity. And I want to ask you the number one question. How difficult is it to convict somebody when there's no bodies? You don't know how they were killed. You can't look at their bodies for injury when they were killed. It's really, you're missing a lot for a prosecutor. I know it's possible. We've seen cases where it's possible to convict somebody with no bodies. But what about in this case?
I think in this case, it's not that difficult. I think they have DNA evidence here linking him to this. They have the coworker who testified that he came into work and was very angry with Yesenia Suarez. We know that she was having an affair, so that gives a motive for doing this. Also, I believe that they're going to have investigators testify, if they have not already, that no one tried to get her passport, apply for a passport. She didn't go to get money. You know, she was at work the day before. So unless this is something that she really took affirmative steps to plan for her disappearance, it just doesn't seem plausible that she's alive.
Right, as you said, we heard the testimony from Investigator Ford, who said there was no bank activity, she wasn't trying to get a passport, no one saw her, they ruled her a missing person. Yeah, I think in other cases where there's missing bodies, you really need strong circumstantial evidence. You need witnesses, you need videotape footage, you need DNA evidence. And we don't have videotape footage here, but we really do have a case. We see what's happening. And one of the people that's helped to lay this picture a little bit is Tyshawn Jackson. This is a name that keeps circulating throughout this whole case. Now, who is Tyshawn Jackson? Well, he is the neighbor in this case, the neighbor who testified, and then we'll talk about it, Deborah. He's 25 years old. Took the stand against Luis Toledo, and he said that they were neighbors. They didn't really know each other that well until they got into barber school at the same time. He'd been out over to Toledo's house a few times. He remembers the kids. At one point, he started to tear up on the stand talking about these kids. Now, I'll talk to you about what his story was and then what Luis Toledo said. Well, Mr. Jackson said he wondered at around 6:11 a.m. on October 23rd, 2013, which is the day that Yesenia Suarez and her two children went missing. Someone knocked on his bedroom window. Who could that be? Well, it was Luis Toledo. He was dressed in black, wearing a pair of dirty boots. Those dirty boots, remember, were tested for DNA, and it appears that Toledo's blood was on those boots. Jackson said Toledo told him he needed his help. So he walked outside, waited by Toledo's Saturn, and afterward, Toledo asked Jackson to follow him. Toledo drove Yesenia Suarez's Honda Accord, while Jackson followed in Toledo's Saturn. They headed towards Sanford, and after about 30 minutes, they arrived at a Publix parking lot in Seminole County. What happened after that is, as they drove into the shopping center, Jackson saw Toledo wiping down Suarez's Accord. And this is very important because we keep hearing in this case about Mr. Toledo wiping things down or the strong smell of cleaning supplies. In fact, there was a strong smell of cleaning supplies in the vacuum cleaner that was found at the bottom of a dumpster. Jackson said Toledo had a bottle of cleaner and was wiping down the edge of the car door. Toledo then took out the Accord's trunk mat and a plastic bag from his wife's car and put them in the back seat of his Saturn, and he asked Jackson to scoot over. Toledo then drove back toward home. Toledo, according to Jackson, was acting kind of frantic and looking around. Now, here's where it gets really incriminating for Mr. Toledo. According to Jackson, Toledo said to him, "I snapped. I snapped." Jackson said he didn't ask Toledo any questions. He didn't want to know what was going on. He felt very scared. Why this is all important and where this all comes back to is because Mr. Toledo, in his interrogation, which we'll probably hear tomorrow, he accuses Tyshawn Jackson of being the killer and disposing of the bodies. Deborah, I went into that whole long explanation about Tyshawn Jackson. Now Toledo is blaming him for the crime. What do you make about this?
I don't think it's too believable. I think that Jackson is the one that sounds credible. It sounds like everything he's saying is playing into the prosecution's narrative here. So I don't think that Toledo is a very believable defendant.
Yeah.
Or his theory of the defense is very believable.
They went to barber school together, so why is that important? There was a black cape found at the bottom of this dumpster by Petco. Oh, maybe if it wasn't Toledo's, it could be Tyshawn Jackson. That doesn't really work because you add up all of the blood stains that were found in the home. You add in the fact that those boots had blood stains on them. You have a witness testifying against them. You know, let's not forget, what started this whole thing was an affair. Okay? It was an affair that Yesenia Suarez was having with Kevin Dredden, and then Mr. Toledo went into their workplace and caused a whole disruption, whole scene. Now, I know motive isn't an aspect of this crime. It's not an element of the crime, but it sure does help. How much does it help in this kind of case?
I think that this case, it helps a lot. Clearly, there was a reason that he wanted to kill Yesenia Suarez. It could be a heat of the moment thing, that he was so frustrated that she was having an affair that he then took such great lengths to take her life as well as her 2 children's. And it's not something in reality that he wanted to do, but he did it because he was so angry due to the affair. It's not an excuse. You know, oftentimes as a defense attorney, you're put in this position where you're trying to come up with some kind of explanation, and sometimes there's just no excuse. There's no excuse for taking someone else's life. I recently had a manslaughter case where my client did have a reason for taking actions, but then that actually bolstered the prosecution's theory. It was a motive-based thing. So it does come down a bit to motive, although that's not what's being, you know, tried here. The trial here is whether or not he did it, and as you just listed, there's circumstantial evidence as well as direct evidence.
I want to talk about the charges, okay? So he is charged with second-degree murder in Yesenia's killing and first-degree in the killing of the 2 children, because apparently the theory is that he tried to get rid of them as witnesses. If it is, if it was a heat-of-the-moment kind of killing, what would be, let's talk to the layman, talk to the viewers here. We all know that is involuntary manslaughter, voluntary manslaughter, excuse me. Why not charge him with that? Why try him with second degree? What is the distinction there? How can you get one and not the other? And I mean, the first degree murder makes sense for the kids. It's he premeditated it, he deliberated on it, he planned it maybe, he knew what he was going to do. But then I know the stronger charge is second degree, but let's make sense of that. Why is it second degree? Why is it not involuntary manslaughter? I mean, I think that from my experience, second degree is when you really show a depraved indifference to human life. You commit an act where you're really doing something where it results in the killing of somebody else. But maybe you could speak a little bit more about why go for that second degree. Is it just a better charge? Is it just, let's see what sticks?
Well, unfortunately, I'm not as familiar with Florida laws as I am with New York State, so I had to just Google it.
Sure, no, that's okay.
And, you know, I agree. I don't know that I'm in love with this charge, but I think that because it's a depraved mind without regard for human life, it actually makes sense. I think that the prosecution here should be commended for not overcharging. We've seen in a lot of these high-profile cases where the prosecutor goes for the maximum charge and then they don't end up getting a conviction. This is somebody that did have a heat-of-the-moment argument, and that would make sense that you could liken that to a depraved mind. So I do think that this charge here makes sense. And then he actually formed the intent, as you said, to murder these poor little children because he wanted to get rid of them since they would not be witnesses to the crime. You know, this whole thing is a disgusting tragedy.
Right, and if he is convicted of killing either of those children, that first-degree murder charge, which is what they wanted to get, he could be sentenced to death. And we just saw a little bit of an update for the second-degree murder charge, just to explain why he is convicted. He is charged with second degree for Yesenia. As you said, that's that depraved mind. Florida state laws permit the prosecution of this second degree when the killing, there was no premeditation, no planning, but the defendant acted with enmity towards the victim, or the two had an ongoing relationship. Remember, this was his wife. So unlike first-degree murder, second-degree murder doesn't necessarily require an intent to kill. So maybe, couldn't you imagine something? He was angry. He knew about that affair. He comes back. He confronts her. Things get out of hand. She dies. Go after that second-degree murder charge. You got 2 witnesses there. You go after them, the 2 kids. This is really, really horrific when you really break it down. Let's talk about that death penalty, okay? Can you explain to our viewers a little bit, if he's found guilty, what happens for him trying to get tried for the death penalty?
Well,
how does that work?
He's going to have a separate hearing on this. And the same jury, we've seen this in a lot of high-profile cases in Florida. So you actually, on this channel, have shown jurors what happens. If he is convicted, then there will be a death penalty phase where the juries determine whether he should receive the death penalty. And I think in a case of this magnitude where 2 children lost their lives for no reason, it's likely that he is going to, the death penalty is like what I would liken to a felony bump up. So if you just hit somebody in the face and it's a bar fight, that's a regular assault. But if you punch an MTA worker or a police officer, it's going to be a felony bump up. So this is like a bump up. You murder two children that have no ability to defend themselves. To me, that's the death penalty.
Absolutely, and they were so young. They were so young, so innocent. We look at those pictures, we put them up, and you could see how beautiful these two children were. Look at that. It's really shocking. It's really shocking to hear that this happens. So it's in these kind of cases we do see the death penalty happen. And then there's obviously a series of aggravating and mitigating circumstances, but from what we know, there seems to be a lot weighing towards that aggravating. But correct me if I'm wrong, there is evidence that's allowed to be introduced into that phase that you might not be able to have at this phase, correct?
Absolutely, yes. It's probably, I don't know, New York State does not have the death penalty. The federal courts do. It's a different evidentiary standard. Oftentimes a trial versus another proceeding could be a different standard. I believe it is with the death penalty. So, I think that this juror seeing those toys from out of the trash, the dumpster, when I saw that, when I was preparing to be a guest today, just seeing that really, really, really pulls at your heartstrings.
Because jurors are human beings. They're seeing this as much as they should base it based upon the evidence alone. Seeing that really does create an effect. I'm curious, do you see, what is the way the defense can turn this case around when they get the case? When right now the prosecution's still putting on their side, what does the defense need to do, if anything? Stumped ya.
It's a very hard question to answer because I'm really not sure what angle they're going for here. Unfortunately, it does seem like the investigators are testifying credibly. Something they would maybe try to do is attack the DNA evidence, attack the mechanisms that were used to retrieve it, make the arguments that you brought up before that, there are a million different hits or 10 different hits, and due to the location where you found it, it doesn't, maybe somebody else did this. Just because her blood was found in the closet doesn't mean that this man killed her. So you try to poke holes. In a case like this, it's very hard to defend it. It might just be a loser of a case where your client wasn't being offered anything. It's possible that they could have even said in plea negotiations, your client has to plead to the charge and we're recommending the death penalty. So it's possible that they were going to trial just to spare his life. I don't know how someone serves a life sentence. Even horrific people are sitting in jail, and I'm not saying it's okay to commit crime. I'm certainly not condemning it, but being in jail is close to impossible. It's also close to impossible for the people's families, because then their life becomes having this loved one who's incarcerated, and then they have to go and visit, and it becomes a whole production.
Right.
And then also it's very costly for the family because they have to give money to the inmate, who then makes very expensive phone calls. I mean, these phone call companies that are running the jail phone calling systems are making a lot of money. It's a very big business. The jail industry is a huge business. So there's just so much that goes into it, taking somebody's life versus not taking someone's life. In this type of case, I do think you have enough direct evidence pointing him to the crime. As a juror, I would have a very hard time saying, yes, we should take this man's life, unless you have a lot of direct evidence linking this individual to this act.
So it's possible that even without bodies, he could be convicted and sentenced to death, even if you don't have bodies. We've seen that before.
I don't know. I don't know if there are prior cases without bodies. I do agree with you that for the death penalty phase, that could be a very big argument that the defense makes. I don't know that the bodies are such a big factor in this murder case.
Now, from all accounts, based upon our understanding of their relationship, it didn't seem that Mr. Toledo had a lot of money. I think one of the problems that they had in their relationship was he was struggling to be financially able to take care of the family. I think he was really taking care of the kids. Do you see a situation where there could also be a wrongful death lawsuit? But again, he doesn't have a lot of money. So how does that work? Maybe you could explain a little bit about, we saw it in OJ, he was not found guilty, but he was found liable in a wrongful death suit for over $33.3 million, I think that's what the number was. But this guy doesn't have deep pockets. So can you explain a little bit about whether that's an option?
I don't see why the family would do that here. I think they're just looking for justice to put somebody away for this atrocious act that was perpetrated against their family member. You know, we don't know this woman. We don't know her at her core, but she had 2 children. I'm sure that she had a relationship with her family members. They now have to live every day without their daughter, without their sister, without their grandchildren. So this must be very trying for them.
Yeah, it's just horrifying. We did talk about before that the motive in this case seems to be because she was having an affair, and we were talking about what the defense can do. Well, let's see what the defense did when they cross-examined her lover, Kevin Dredden, in testimony from the other day. Take a look at this.
Now, you got back from Uganda, is that correct?
Yes.
But nothing happened. So nothing happened between you and Mrs. Suarez until you went to Alabama, isn't that correct?
Correct.
Nothing actually physically happened until you went to Alabama, is that correct?
That's correct.
But prior to that, you all had been flirting with each other by text or however it was you did that, is that correct?
I believe so, that's correct.
Okay, well, when was that code put in?
The code was when we got back from Alabama.
Oh, so that was after, okay. But prior to that, you all were communicating about hooking up, weren't you?
No, prior to Alabama?
Yeah.
Prior to the visit in Alabama, we were not communicating about hooking up.
So are you saying that basically 2 weeks before you went to Alabama, you didn't know you were going to have sex with us?
Oh, well, okay, yes.
Prior to Alabama,
yes,
right?
Yeah.
So you
correct.
did know, right?
Yeah.
Try
You
not
did.
to speak at the same time.
So you did know?
I did know.
Okay. So from January to sometime in September, there was no physical activity, but you were sometime in September beginning to flirt again, is that right?
Yes.
And then made arrangements to have an affair when you went to Alabama a couple of weeks ahead of time, right?
Yes.
Okay. So you knew what was going to happen when you went to Alabama? That's
Yes.
what I'm getting at.
Yes.
All right. Now, on the day that everything happened, as far as Mr. Toledo finding out about the affair, you found out that he knew from Ms. Suarez, is that right?
I got a call from him.
So is that the first time you knew that he knew?
Yes.
So it was, you found out from Louis Toledo himself,
Correct.
who called you himself.
Correct.
And the first time he called you, he asked to meet with you, didn't he?
Can't remember if it was to meet with me. But it was, hey, I know about this. And
He wanted to talk about it, right? He wanted to talk with you about it, didn't he?
are you asking that question?
Yes.
Well, he was talking on the phone with me. He was talking on the phone with me, yeah.
Mr. Dredden, when he called you, he told you that he knew what was going on, didn't he?
Correct.
He told you that you don't remember if he told you if he wanted to meet with you, but he said that he had text messages, didn't he?
Correct. Correct.
You deny the whole thing.
I denied it.
You lied to him.
Correct.
And then you asked for the text messages. Is that correct?
Can't recall if I asked for him.
Okay, well, when the state attorney asked you, you said you asked for the text messages and he sent you the text messages. Do you remember saying that just a few minutes ago to the state attorney?
I actually don't remember saying that.
Okay.
I asked for the text messages, but I know that he sent them.
You don't know if you asked for them.
And you're saying just now, he said, I asked, he asked that question and I said, I asked that. I don't recall that just now.
You don't recall that.
Yeah.
Okay.
But I asked for the text message. I don't recall it.
Out of fairness, I don't recall hearing that question.
Okay. May I approach the witness, Your Honor?
Yes, sir.
This would be the transcript of the audio recording interview, page 20, line 17. May I approach?
You may.
Okay.
So did you refresh your memory?
I did.
Okay. So when police asked you about it, you said, starting at line 17, but he was persistent to talk. It's the same call, right?
Okay.
He was persistent to talk, so I started talking to him. And I was like, well, look, man, send me the text messages. You said that, right?
Yes.
And we'll talk in 30 minutes. Do you remember saying that to him now?
Yes. And I'm sorry, I don't know if I can talk right now, but...
No, sir.
No? Okay.
He sent you those texts, didn't he?
He did.
You still denied it even after that?
I deny what?
The affair?
I didn't.
I'm
I
sorry.
did.
Yes, sir.
Yes.
Now, at some point, you get back to your place of business and you speak with Ms. Suarez about what's going on. Is that correct?
Yes.
So she's naturally upset and tense about what's going on, right? I mean, everybody's been found out.
Yes.
I mean, your boss knows, but your wife doesn't know, right?
My boss did not know.
Well, he was screaming out whatever he was screaming out.
My boss?
Not your boss. Mr. Toledo came to the workplace right after that, right?
Yes.
He was telling everybody, right?
Yeah, he was screaming, yelling. I don't know.
So your boss heard it.
My boss heard it. I believe so.
Okay. Later on, you went home and you told your wife what happened, but you didn't tell her about the affair, right?
Correct.
So after you get out of your car from where you had been, I'm back in the morning. I know I jumped around a little bit. So I'm back in the morning. Now you're back to your place of business. You've talked to Lewis on the phone. He sent you the text messages. You see Ms. Suarez. Is that correct? At the office.
Yeah. So, yeah.
She tells you that, well, I don't want to put words in your mouth, but I understood you to say in here that she was upset. Is that correct?
That she was upset?
Yeah, because everything had been found out. Naturally, right? Stressed?
Disappointed? I don't know
Disappointed.
if I used the word upset or not.
Okay.
But yes.
Whatever word you used.
Okay.
Concerned, whatever it was, everybody wasn't feeling right. Is that right?
I would agree.
Okay. Shortly thereafter, Mr. Toledo shows up at the workplace. Is that correct?
Shortly thereafter,
Speaking with you.
yeah, we spoke, yes.
Okay. You spoke outside, and Ms. Suarez was there as well. Is that right?
I'm sorry?
You spoke to Mr. Toledo at your place, but that was in the parking lot. You went outside to smoke a cigarette. Is that right?
I was outside already, yes, at that time.
That's when he drove up, right?
Correct.
Okay. When he came up, you indicated that he was upset with you. Was he?
What do you mean when he came into the office? When
Yeah.
he
He
got
got
out
out of the car and saw you, and you walked over to him. Was he upset with you?
Well, yeah.
So you're not surprised that he was upset with you, are you?
Was I surprised that he was upset with me?
Yeah.
I don't think so, no.
Okay.
Yeah.
And you're not surprised that Mrs. Suarez would be upset that these two particular men in front of her are arguing in the parking lot of her business, are you?
What do you mean, arguing? You said these two men arguing?
That'd be you and Mr. Toledo.
I don't recall arguing.
Okay, whatever it is you recall, sir, whatever conversation, however you want to characterize it,
It was an argument, though.
Okay.
You said
Allow
argument.
him to finish the question. Go ahead.
however you want to say it, Mr. Toledo is there and you were there talking about an affair you were having with his wife in the parking lot of that business. Isn't that correct?
Yes, correct.
Okay. He and you separated, is that correct? You went your separate ways, isn't that right?
I departed. Yeah, I left back to the office.
Okay.
Well, I mean, and I'm just sorry for the questions, but just the clarity of it is just is why I'm asking a question to you.
Okay.
Clarification.
So if you walked one way and he walked a different way, is that separating?
Yes.
Okay, so you separated. You walked one way and he walked a different way. Is that correct?
Correct.
Okay. Later on, a few minutes later, however long it was, you heard him inside the office. Is that correct?
Yes.
He was upset. Is that correct?
Yes.
Do you know what he was upset about?
The affair. Yeah.
Okay. He left. Is that correct?
Yeah, he left.
Okay. When he left, the police came. Is that correct?
Correct.
Do you recall speaking to an officer?
I recall speaking to the officer at work.
How long did you speak to him?
Not long. I can't.
Minute?
Don't know how. I'm sure the officer would put the time in there, but maybe it was a few minutes. You have to confirm with the police report.
Okay. But you spoke to him.
Yes.
Did you tell him that Mr. Toledo was there because you were having an affair with his wife?
No.
Did you tell him you didn't know why he was there?
No.
So you didn't lie to the policeman?
I did not lie to that guy. No, that showed up. Policeman.
Just after that sometime, I'm assuming, is when you asked to go home early?
Correct. Yeah.
You went home early and saw your wife, is that right?
Correct.
Did the police come to your house that night? The 22nd?
No.
Somewhere in that evening is when you began exchanging texts again with Ms. Suarez? Or even if you didn't exchange them, you received them, or whatever was going on?
Well,
Is that right?
what do you mean, whatever was going on? So sometime in that evening, can you clarify that?
Yeah. Did you hear from Ms. Suarez that night? Or her phone?
Yes.
Okay. Your wife was there then, right?
Yes.
Your wife knew you were receiving those texts, right?
Yes.
You were trying to ignore those texts, right?
Yes.
You did tell your wife generally what happened at your office, is that right?
Everything except the affair.
Well, did you tell her that you were accused of that?
Yes.
So she knew something was going on, right?
Yes.
And then you started getting the text messages. And she saw them, right?
Yes.
She was asking you about that, right?
Correct.
She was asking you, why is Ms. Suarez texting you if nothing happened?
Well, I can't remember exactly what she said then, but she was, yes, concerned what was going on here.
So finally, you'd gotten so many texts that you decided to call her.
Correct.
Nobody answered right away until you sent a text.
Correct.
Now, when you spoke to Ms. Suarez on the phone, when she called, She called you, right?
Yes.
In response to that text.
The text.
You say that her speech was slurred. Is that what you said?
Yes.
Do you know what she'd been doing prior to her calling you?
No.
Do you know if she had a drink?
No.
Do you know if the day was so upsetting for her that she took a sleeping pill?
No.
Do you know if her kids were sick?
Don't know.
Do you know if she was sick?
I don't know. I told you what I know.
Okay. You said she was stressed,
Yes.
and the conversation with you was stressed?
Say it again.
The conversation with you on the phone was stressed?
The conversation with me on the phone, how I felt that she was stressed. Correct.
Do you think that it would be stressed if, for her, because the affair was exposed?
I believe so.
So when you're not saying that this conversation was forced or stressed because Mr. Toledo was doing something to her, are you?
Objection calls for speculation as to what the witness may know about.
Sustain.
Because he doesn't know. So, okay.
Counsel, I have ruled. Next
No,
question, please.
I'm sorry, I was just trying to clarify it.
Counsel, I have ruled.
I got you. I forget how long that conversation lasted, sir. Do you know how long it lasted?
Yeah, you got the records.
A few minutes? Was it a few minutes?
Yeah, you can refer to that, please.
Okay. The next day, the police came to your house, is that right?
Yes.
The police came to your house more than once, isn't that right? More than one agency came.
Yes.
So who came first?
I don't know what agency came.
They came in your house, right?
That's right.
Your wife still doesn't know that you had an affair, does she?
No.
And the police are in your house.
Well, I can't say she doesn't know at that time. If
you
I was
haven't
having
admitted it
affair,
to her.
I haven't admitted it, yes.
Okay.
And the police are in the house.
They're in your house. And then later on that day, they were in your house again or in your yard interviewing you because Miss Suarez was missing. Isn't that right?
Yeah, out back, yes. Mhm.
You stayed out back because you didn't want your wife to hear it. Isn't that right?
I can't remember. No, I went out there and asked them, can I smoke while we're talking? That was the reason I was out there. I don't believe my wife was, I don't know if she was upstairs or downstairs at the time. But if you're alluding to if I was trying to hide and go out there to not tell her, if she was right there, I probably at that time would have went away to talk, but I don't think that had it. I was out back, and I'm not for sure where she was at, and I was smoking a cigarette. Yeah.
May I have a moment, Your Honor?
Yes, sir.
May I approach?
You may.
The record's deposition, page 75, line 7. Sorry for the delay.
Thank you.
So, sir, do you recall me asking you, was your wife there when they were talking to you? And you said, my wife, no, N-O, because at the time she did not know. And then I asked you, but she wasn't there, and you said, where? And I said, well, this was at your house, right? And you said, at my house. At my house, she was upstairs or inside. Do you remember that?
Yes, and that's what I just said.
Okay. Later on, you were asked to go to the Volusia County Sheriff's Office, is that correct?
Yes,
And you did that, isn't that correct?
that's right.
And you took your wife with you, isn't that correct?
Yes,
So when you say that you told your wife about everything, that's really when you did it, isn't it?
no, it's not.
You did it, you didn't tell her on the way to the Volusia County Sheriff's Office?
No,
Did you tell her after?
well, yeah, after, but
Because
you
you were...
mean that same day?
Say again?
What do you mean after?
Let's just clarify it. You were asked to go to the Volusia County Sheriff's Office, is that correct?
That's right.
You went there with your wife, is that correct?
That's correct.
At that time, she still did not know that you were having an affair with Miss Suarez.
I still did not tell her.
Still hadn't told her. You went there to be interviewed because she was missing, isn't that correct?
I went there to interview to explain of the night. I don't think I even knew about it being missing or her being missing or anything like that. I just can't.
You don't think you knew that she was missing by then?
I didn't know what happened at that point.
But they talked to you when you got there, didn't they?
Now, yeah, but not about
they
her.
talked-
They were only concerned about. I'm sorry.
Go ahead. They were only concerned
They
about what?
talked about her. They talked about asking me the questions, not about what was going on. I still didn't. I was still in the dark and didn't know.
You were still in the dark and didn't know?
Well, I could put things together and figure out that something bad has happened. And I actually believe that's what I was told. It's just something, it's not a good thing that we're here and what happened.
They searched your house, didn't they?
Yeah, they looked through my house.
Now, you got back from Uganda, is that correct?
Yes.
But nothing happened. So nothing happened between you and Mrs. Suarez until you went to Alabama, isn't that correct?
Correct.
Nothing actually physically happened until you went to Alabama, is that correct?
That's correct.
But prior to that, you all had been flirting with each other by text or...
Welcome back to the Law News Network, everybody. This is Jesse Weber. Thanks for joining us. You're watching prior testimony in the Luis Toledo case out of Florida. Again, this is the case of 35-year-old Luis Toledo, who's charged with second-degree murder in the killing of his wife, Yesenia Suarez, and first-degree murder for the killing of her two children, Talia, who is 9 years old, and Michael, who is 8 years old. The bodies of all three have never been found, and if he is convicted in the deaths of either of those two children, he faces the death penalty. You were just watching the prior testimony of Kevin Dredden, the man who Yesenia Suarez was having an affair with, and he was under cross-examination. I want to talk to Deborah Blum, our criminal defense attorney here, to talk a little bit about this cross-examination, asking him all sorts of questions about, keep reiterating the fact, did you tell your wife you had an affair? When did you tell her you had an affair? Keep questioning about whether or not their relationship that with Yesenia, trying to understand, was Mr. Toledo mad or angry at certain points? At one point he testified to the fact that she seemed stressed and her speech was slurred on the phone. This is one of the last conversations he had with her. What is the defense really trying to point at in their cross-examination of Dredden? Saying he's not a good guy, he's a liar, he might be over making assumptions about Mr. Toledo? What are they trying to put? We know this guy did wrong, and as we talked about in the break, he must feel extremely guilty about what happened. His affair seems to have resulted, or at least he might think that his affair seemed to result in the death of these 3 individuals. But what is the defense really trying to do in their cross-examination?
I think here their strategy, their goal would be to attack his credibility, because he's the one that testifies to the argument between husband and wife at the workforce. So the defense wants to get that out of the juror's mind, because that again goes to motive, that, you know, that the husband knew about the wife's affair, so that would give him a reason to have this heat of the moment passion type killing where he killed his wife and her children. So I think the defense really just wants you not to believe a word that this man is testifying to, so they're trying to attack his credibility. On the flip side of that, this might be a witness where you make, as a defense attorney, a strategy call where you're going to really only ask him limited questions. Sometimes there are witnesses that you're not going to really be able to get anything out of. Look, we all know the 2 of them were having an affair. You know, does that make him a good person? That's really not the question here. It's just whether or not you believe his testimony, and I feel that he's testifying credibly. He at one point said, "I told you everything I knew," and he doesn't appear to be lying. So as a defense attorney in that position, I would probably make the judgment call that I'm just going to leave it, because you're not going to get anything out of that witness.
I agree. And today we're talking about all these different parts in the Luis Toledo case because the jury was sent home for the day so that the judge and the attorneys could work together and try to see what parts of his interrogation video, Mr. Toledo's interrogation video, can be seen by the jury tomorrow. Again, it's going to resume tomorrow at around 9 a.m. We're going over this case, talking about this case. One of the parts that we think is going to be introduced into this, that will be allowed for the jury to see, and Deborah, I want to talk to you about it. Prosecutors have alleged in their opening statements that Toledo told investigators, "I'll never tell you where the bodies are." If the jury hears him saying that, case closed?
I think that plus everything else, case closed. You know, as a defense attorney, Aaron Keller just walked in. He always jokes with me that I never admit that anyone is guilty. Here, I think that the prosecution really does have a strong case. I think they made a good judgment call with only charging second-degree murder. I think the charge fits perfectly for the crimes charged. So I just think that having this statement come out of the defendant's mouth, "I'm never going to tell you where the bodies are," that's an admission of guilt. That means I know where the bodies are, but I'm not going to tell you. You know, again, it all goes back to when someone is charged with a crime or a suspect of a crime and they're at the police precinct, we all know they're not free to leave. So to give these damaging statements to the police, it's certainly not self-serving.
How does the defense argue that away? Is there any chance of doing it?
You know, in this day and age, there are so many things that dig a tremendous hole for your client. You have Facebook postings that basically where your client can admit guilt. You have cell phone tracking where your client's every move is being traced. So you have so many things that are working against your client. Then to have a videotape confession, in some cases, I do think that the defense attorney could chip away at it. Sometimes I do think the police get a false confession due to their actions. Some think that the police write things out for the defendant to sign, and they have no choice but to sign it. Here, though, when you have a videotape, I think it makes it harder. You know, a signature, a statement, we don't know what that person's handwriting is like, so it can arguably be said that it's not your client's handwriting, they were just forced to sign it. The videotape, I do keep going back to, I think that there's the pre-party before the police go and film the actual interview. I think they say things to the accused that would tend to have the accused confess, but this is not a good position for the defense to be in.
But isn't that more a question for an appeal then? Because we see it in Brendan Dassey in the Making the Murderer situation, where Brendan Dassey, his whole interrogation is being questioned about whether or not those were voluntary statements that were made, or was he under police pressure? Doesn't this not become so much, okay, so now we have an issue of the jury will hear it, they'll make their determination, and then on appeal, that can be a way to overturn that ruling.
I think this is very different than the Brendan Dassey matter. There, his intelligence is
because
in
Deborah,
question.
I'm sorry to interrupt, but let me tell you also this, just to add to the fact, he is also alleged to have said on this tape to karate chopping his wife in the throat and killing her. So again, it's kind of similar in the idea that there two people were admitting to involvement or killing someone.
Right, but Brendan Dassey is of an age where his parent possibly should have been present for the interrogation. So each state has their own rules. I don't think any of those things are at play here. So this is a very different case where this man was read his Miranda rights. He certainly has been involved in the criminal justice system before, I believe, so he should know. Usually people get a bit smarter as they go along in committing crimes. They know not to give a statement, but he didn't do any of that. And the judge already made his ruling that the statements are going to come in. So that is why the prosecution was able to say that in their opening.
And I think the prosecution's doing a pretty good job putting on a strong case, but tomorrow could really be the sinker for the prosecution, really nail it in, and then I'd be very curious to see how the defense puts on their case. Final thoughts, I know we don't have you for much longer. Do you have final thoughts as we go towards the middle, towards the end of this case? We expect it to wrap up, I think, next week.
Well, I'm curious what the defense is going to do. I'm curious whether they're going to call witnesses. I'd like to know that. I don't know if we have a witness list of who they're going to call. I really don't see what their strategy is other than to attack the prosecution's witnesses, and then they're going to say that that all amounts to doubt. This, unfortunately or fortunately, is not a very strong case for the defense. I think this is really a question of whether they're going to be able to save their client's life or not.
Very well said. Well, we're going to have to see, and hopefully we have you back once we hear that videotape, and I'm sure it's not going to be the last. There's going to be objections and ways of trying to explain away certain testimony that's made in that interrogation video, but it's going to be an uphill battle for the defense. So, Deborah Blum, thank you for joining us here today. We really appreciate your insight.
Thank you for having me. I'm going to be here from tomorrow from 12 to 2.
I like that. Promoting yourself. I
Yeah.
should have done it for you. Thank you. So again,